Hi, good evening. It's such a pleasure to be here. Thank you, Russ, for the intro and also for the interest and support that you and Jeannie have given me over the years with my career. And I also want to thank Tiffany Murray and the rest of the folks who put this conference together and the staff of the Fairmont. It's true, this is a stunning setting, and I feel very grateful not only to be the LC keynote, but also to have learned from you all in this week. So after hearing this week about so many potential uses of LLMs in medicine, I did my due diligence, and I asked ChatGPT, quote, suggest a lighthearted way for a law professor to start a keynote to biocomputing experts on the beach in Hawaii. The results, borrowing slightly and modifying Russ's talk from Thursday, were what you might expect from a slightly cocky, I'm going to add slightly inebriated third-year law student. To wit, I promise I won't object if any of you have research that goes over my head file. If my speech is buggy, I can always blame it on the Mai Tais from last night. So that's just a representative sample. But what I realized tying it into Larry's talk from Thursday, actually, is that while medicine is a context where average is good, humor is not a context where average is good. And it turns out that neither is law, or at least criminal law. And what you all do has huge implications for law and also for criminal law. And not just for investigations like facial recognition software, and not just for risk assessment and determining medical diagnoses, but trials themselves, the determination of guilt or innocence in a criminal trial, for example, the moral condemnation of somebody by a community in a public ritual. That's a very heavy concept, and at least historically, it's a very human concept. So the title of my talk is Machine Accusers, the right to confront witnesses in an age of AI. And I guess I can't give you the too long didn't read version when I have you as a captive audience for the next 30 minutes or so, but what I'm going to be pointing out is that the legal rules governing criminal trials, and in particular, the Sixth Amendment to the Constitution, the right of a criminal defendant to be confronted with the witnesses against them, were created for a world where evidence comes from human witnesses, and where we rely on individual lawyers with individual briefcases and individual cases to try to figure out if those witnesses or that evidence is reliable. But that's not the world we live in anymore, which you all know. And much of the evidence presented in trials even today is generated by scientific or technical processes, much of which are now already automated. And its flaws and its benefits are not easily identified or exposed by individual lawyers without a technical background and no research budget from the NIH. And let me just be totally clear that this shift towards machine-generated proof is not necessarily bad. It holds lots of promise for increased accuracy, enhanced knowledge, deep biasing, and in other respects, as you already know, it's very challenging. And some situations are low stakes, like asking it to write your keynote speech for you, but some are very high stakes, life or death of your patients, and in the criminal system, life or death of criminal defendants and crime victims. And what's at stake is not just accuracy. What's at stake in figuring out what confrontation means now that we don't have human witnesses as much anymore and we have these new machine witnesses. It's also about the dignitary interest in having one's accuser look you in the eye and explain why they're saying what they're saying, and for you to face them in open court, or at least that's what the history suggests. And part of what's missing from trial by machine, however accurate or explainable it becomes, is the ability to have that human, ritualistic, ethical element that makes moral condemnation of defendants through criminal trials, if it is ever legitimate and meaningful. Okay, so put it differently, if we're going to have meaningful confrontation in an age of AI, of witnesses, then AI-driven proof has to be sufficiently reliable, contestable, and interpretable to be accurate, respectful of dignity, and legitimate to the public. Okay, so what I'd like to do very briefly in the next few minutes is first give you an overview of what kind of proof I'm talking about that might be interesting to you as the biocomputing community in terms of what's going on in criminal trials right now. And then I will talk about what the problem is, why this evidence is almost entirely unregulated by existing legal rules, and why that's a problem. And finally, suggest a path forward that hopefully you can be a part of as well. Okay, so going back to the first point, to give you a sense of the type of proof I'm talking about, let me start with a case a few years ago in upstate New York involving an unsolved homicide of a young person. Two ex-boyfriends of the victim's mother were the prime suspects, but one had a history of domestic violence but an apparent alibi. The other was a soccer coach at a local college named Nick Hillary. But there was no physical evidence or motive or anything tying these two people to the crime. There was, however, a small amount of DNA on underneath one of the fingernail clippings from the victim, but it was too complex a mixture for human analysts. And so the district attorney sent it to a company based in Pittsburgh called TrueAllele, which is a probabilistic genotyping software model. And based on TrueAllele's deconvolution of the mixture, the company's CEO, Mark Perlin, reported that there was, quote, no statistical support for concluding that Mr. Hillary was the minor contributor to the sample. And indeed, Mr. Perlin would later insist that the evidence suggested that Mr. Hillary was actually excluded as a possible contributor to that mixture. Okay, so based on the likelihood ratio that was calculated. So eventually the DA sent it to another program, which happens to be the main competing program to TrueAllele, called StarMix, STRMix. And in contrast to TrueAllele, StarMix reported a highly damning likelihood ratio, over 300,000 with respect to Mr. Hillary, based on which he was prosecuted for homicide. And by the way, the likelihood ratio that comes out of these sorts of probabilistic genotyping software systems is in a form something like the following, quote, this is from a recent report. There are 3 contributors to the DNA mixture on the gun, and based on the DNA typing results obtained, it is at least 49 million times more likely if the observed profile from the swabs of the texture areas of gun number 1 originated from the defendant and 2 unrelated unknown contributors than if the data originated from 3 unrelated unknown individuals. So eventually the trial judge decided that the StarMix results were generally reliable, but kept them out of the trial anyway because of a lack of internal validation done by the state lab. So didn't come into trial. There was not very much else against Mr. Hillary, and he was acquitted. And that's the end of the story. After the verdict, the creator of StarMix put an addendum, like a memorandum online that tried to suggest, why the 2 programs had come to very different results about the same defendant in the same sample. But the point of the story, I think for our purposes right here, is that 2 purportedly reliable software programs came to very different results with the same DNA sample and the same defendant in a homicide case that could have been a death penalty case if it weren't New York. And it's a homicide. Okay, so how could 2 generally reliable programs come to such different conclusions? Well, one reason is that a judicial finding, like a finding by a judge, that a software program is generally reliable, isn't the same as knowing enough about the process to be able to trust in the accuracy of any particular report from any particular machine or algorithm in a particular case. And it's really hard to feel certain about the latter, the reliability of a program's result in a particular criminal case, without more information than we usually have. So for example, while both of these programs have been found generally reliable by scores of courts all over the country and all over the globe, based on the proprietors' validation studies. It's still the case that, for example, neither has been subject to the type of stress testing that software, I think, typically has to survive to be deployed in high-stakes situations, like elevators. Both are proprietary programs that, they've declined to disclose source code, claiming that it's a trade secret. Neither offers what they would call an interpretable model that explains how it gets its results. Neither allows, as a matter of course, defense attorneys or academic researchers even to acquire a license to conduct independent audits. They sometimes voluntarily allow a defense lawyer to have like a 30-day license before trial. That's my understanding. But just recently, for example, my colleagues in the computer science department at UC Berkeley tried to get a license from StarMix just to do some studies on how it does with relatives, like a laundry basket where there's, lots of people's DNA on something, but they might be related. TrueLeal just refused out of hand to allow them to have a license. And StarMix said at first they were engaged in preliminary negotiations, but then they soon imposed impossible demands on getting a license, like saying that you couldn't publish without their approval and things like that, and so it just never happened. So that's pretty typical, and probabilistic genotyping software obviously isn't the only, algorithm-driven proof in criminal trials. Parties in the US have sought to admit, just to give you another just like smattering of examples, like a Fitbit data offered to prove an alleged rape victim was asleep at the time of the assault and thus was not credible. Machine learning algorithms purporting to determine the authorship of a confession note based on a data set of tweets that were written by 3 different people who had access to somebody's Twitter account. Software, as you know, surely purporting to engage in voice and face recognition, AI analysis of jail phone calls to determine if they are threatening, GPS ankle monitors placing people at crime scenes, fMRI data offered by criminal defendants to prove they're truthful, etc. So on the horizon, which we haven't seen yet, but I would expect in the next 5 to 10 years we will, are automated sensors purporting to detect level of THC in the breath, AI-based medical diagnoses and cause of death determinations, algorithms purporting to determine whether a confession is false based on microexpressions and speech patterns, an algorithm purporting to identify attempted fraud. A recent report by Europol suggested that police agencies create their own customized LLMs for particular types of criminal activity. And in terms of deception, when I asked ChatGPT this week whether it could analyze confessions for truthfulness, it answered that it, quote, can analyze text, such as a transcript of a confession, and provide insights into truthfulness based on linguistic cues, writing style, and content. And as a caveat, it said, it currently has no analytical ability to conduct forensic analyses itself other than language-related analyses, such as authorship attribution, but it shouldn't be the sole basis upon which you make a conclusion. And then, this week, perhaps on the horizon, you could imagine magnet axiom being offered to prove a defendant's intent to groom or lure an underage victim in a chat for purposes of prosecuting attempted child abuse. Or a program like Vet LLM predicting diagnoses from unstructured notes. I could see it being used to determine whether a particular clinician has rendered a correct diagnosis from their observations in a criminal case. Or the automated neural nursing assistant, Anna, might someday be deployed in jail settings, I could imagine, to determine whether somebody's malingering. So I'm putting these out there because these tools will be used in ways that they are deemed useful by the system. And they're already being used that way, sometimes perhaps in off-label ways, if you will. But if there's a way to use them to try to get proof in a criminal case, they will be used in that way. All right, so number 2, why is this evidence so unregulated? Don't we have rules of evidence, and isn't this evidence? So why is this so new? It's just higher tech, that's all. And after all, no evidence is perfect, and in some ways, these algorithms are replacing things like eyewitness testimony and confessions that are increasingly thought to be unreliable, with racially disparate results, things that would suggest that a move towards algorithmic proof is definitely not all bad. And indeed, Mr. Hillary, walked out of court a free man, perhaps because a judge screened out the evidence. Maybe the system is working the way it should. But one problem is not just that general reliability of a program isn't enough, but also that we don't settle for general reliability when it comes to a human witness. We subject human witnesses to a lot more scrutiny than that. And so, if Russ testified as an expert in my murder trial, which I hope and expect will never happen, it wouldn't be enough for the judge to say, I think Dr. Altman's trustworthy, and just let him say whatever he wants, leading to my conviction. Instead, I would have a chance to, question Russ on the witness stand, see the beads of sweat rolling down his forehead when he's lying, if he's lying, et cetera, to impeach his credibility with prior statements that he's made that may have been inconsistent with what he's saying. All of these things, I've got this big toolbox when it comes to human witnesses. But those existing ways to attack witnesses were created for humans. So let's start just really briefly talking about the law, the Sixth Amendment Confrontation Clause. I know you didn't come here to talk about the law. I know most of you are not lawyers. But I've spent the week learning about, disease pooling and petabits. So give me 30 seconds. Here we go. In 1791, when the Sixth Amendment was ratified, the right of confrontation meant the right to have one's accusers live in court and on the witness stand so that you could physically confront them, again, look them in the eye, ask them questions, see their demeanor, see the beads of sweat roll down the forehead. And the rationale for including that right in the Constitution was partly about accuracy. James Madison and the other framers thought an accuser would be less likely to make a false accusation against somebody if they knew that they had to do it in court and not behind closed doors. And the framers were particularly concerned about something called trial by affidavit. It turned out in the 16th and 17th centuries in England, they had this practice of taking sworn affidavits from witnesses and using them as the proof at trial instead of the live witness. And the framers of the US Constitution thought that wasn't fair, and so trial by affidavit was one of the main reasons that we have the Confrontation Clause, according to the Supreme Court, which is never wrong. But the right to face your accuser isn't about just accuracy, like I said. Scholars and historians recognize that there's this dignitary interest in not being condemned by accusations that you don't understand or that are made behind closed doors. And instead, we want witnesses to explain themselves and take moral responsibility for their accusations. And especially when somebody's freedom or even their life are on the line. And you can find this dual purpose in other trial rights that are listed in the Sixth Amendment. The reason that in this country we have public trials, the reason that we have trial by jury and not judge, it's not just because we think that those modes of adjudicating people's guilt or innocence are more accurate. People make fun of lay juries all the time as being inaccurate. But it's partly because it's that ritual. It's the human element in the trial that makes it legitimate, makes people feel like they're being treated fairly. It's part of a ritual we find important to our definition of justice. Okay, well, these centuries-old principles are great, but they don't work on AI, at least on the surface, they don't seem to. Because when your accuser is an algorithm, these tools for testing witnesses seem antiquated. You can't cross-examine Fitbit, you can't see the beads of sweat roll down Google Bard's face when it hallucinates. And so is the right of confrontation meaningless in an age of AI? And I think the answer has to be no, of course not. It can't be that the same framers who cared about preventing trial by affidavit wouldn't care at all about trial by machine. Like if James Madison could be here on this beach, overdressed as he might be, I would think that that's what he would say. And so before I suggest solutions and get to the very last part of the talk, I just want to say that, this seems like a new problem, but it's actually an old problem. And we're not starting from scratch. We actually have some clues from history about how to deal with this. We've had witnesses who haven't been able to be cross-examined before. Animals. We've had bloodhounds as witnesses for centuries. We've had basic scientific instruments like barometers and thermometers for centuries. And we've also had humans who are not present at trial, maybe because they're sick or they're deceased or they just didn't show up. And so, but their accusations still come in, what we call hearsay accusations, and they can still be subject to attack, just not through cross-examination. So how in history have we allowed parties or criminal defendants to attack the credibility of a dog or a thermometer or a human hearsay declarant? Well, lots of ways. We've required that judges find them decently reliable. Sometimes we've given defendants the prior statements of people to be able to check for inconsistencies and inaccuracies. We allow absent hearsay declarants to be attacked with evidence of bad character for truthfulness or bad eyesight or a motive to lie. All of these things that don't necessarily involve cross-examination. So, what does confrontation mean? Because after all, the Sixth Amendment says confrontation, it doesn't say cross-examination. And in my work, I've suggested that confrontation means a right to meaningfully scrutinize the government's witnesses, meaningfully scrutinize the reliability of the government's proof. And there isn't anything radical about that. We've been doing it for centuries. It's just that somehow along the way, the lawyers got in the mix and decided that cross-examination was the most important. And that's just not historically accurate. It's just a way for lawyers to make more money, even more money, I should say. Okay, but we don't have analogous rules of disclosure for machines. We don't have a right to, prior runs of the machine or prior statements of a machine. The few courts that have looked at this issue have decided that the confrontation clause just doesn't apply to machines. Defendants have no legal right to access these machines pre-trial. They have no right to access source code, no right to insist that the program's been validated by a financially independent auditor, no right to the prior output, no right to any interpretable or what you might call glass box AI model, no right to calibration records, training data set access, funding to get another algorithm to try to verify the result that we have, none of that. The only thing that some courts have said that you do have a right to is to physically confront the proprietor of the program. Let's say the CEO of the company that created the program. And so if ChatGPT were your accuser, you might have a right to cross-examine Sam Altman. That's not nothing. There is somebody who's on the stand taking moral responsibility for that accusation, and you can find out a little bit about how the program works. But it's not the same as having that AI system be interpretable or having the ability to attack the credibility of the system itself. Something that came up on Thursday, a question from the audience was, how do we know these LLMs are working? And one answer that I think Dr. Moore gave, and apologies if my memory is incorrect, but one answer was, as long as it's saving patient lives, that's kind of a feedback that you have, that something is working the way that we at least want it to work. And in the legal system, we don't have that kind of feedback because you convict someone, but it's hard to tell that, that conviction is right. It used to be that fingerprint examiners would get on the witness stand and say that they have a 0 error rate. And when you ask them on cross-examination, what do you mean zero error rate? They would say, I've never had a conviction that has resulted from my work been overturned on appeal. I've never had anybody be exonerated through DNA whom I've accused. And that's their feedback. And so it's very difficult to validate with our current models and our current rules of evidence to really have trust in that result. Okay, let me wrap up by talking about possible paths forward. I assume, hopefully, I've convinced you AI is coming, criminal law. It's already there. Existing rules don't necessarily regulate it in the way that we much more deeply regulate human proof. And there might be reasons that just like a general judicial stamp of approval based on a pile of validation studies that are from the proprietor itself shouldn't be enough. And I should say that some folks out there are concerned about this problem and thinking about what to do about it. The European General Data Protection Regulation, GDPR, recognizes a right of contestability. They have a right, for a subject not to be non-consensually subject to a decision that is solely based on automated processing. You could imagine something like that in criminal trials here. Maybe the results of an algorithm should not itself be sufficient for somebody's, legal guilt. Here in the US, a colleague and I also helped advise the staff of Representative Mark Takano in California, who drafted a bill called the Justice in Forensic Algorithms Act, which went down in flames. So I'm like 0 for 1 in Congress. But it would have provided, gotten rid of the trade secret privilege in criminal cases. Not trade secret protection. You'd still have substantive trade secret protection, but not be able to use a privilege to not disclose things to the other side. Limited defense access to the program, be able to do independent audits, have the National Institute of Standards and Technology, NIST, have a testing program, sort of like the FDA for drugs. Like, yes, we know this is proprietary information, but there's got to be some repository where, someone who's in charge of figuring out if this stuff is reliable is able to look at the materials that they need. And then a last thing that's being done is the advisory committee to the federal rules of evidence. I got to talk to them in October about some of these issues, and then we're talking again in April on possible new rules of evidence that will deal with machine-generated proof. And if any of you have ideas or want to be a part of that, please let me know. I've given them, a list of some possibilities, and I've heard some possibilities this week. Red teaming and gamification and words that I hadn't used in this context. And I'd love to hear your thoughts on what those tools should look like. That would be confrontation, if you will. 2 Duke University professors just came out with an article saying that we should just have a requirement that in criminal settings, AI must be, quote, interpretable, which they say is different from explainable. They say interpretable AI means that an observer can decipher the decision-making step by step. And whereas explainable is simply that after the fact, you can prompt the system to speculate in terms of how it got its answer. That's how they're defining those terms. So, we could ban certain types of AI from criminal or legal settings in general. Just like we ban certain types of human testimony from the courtroom. Like if you are incompetent because of a mental condition, small children who don't understand the oath, no offense to the 3-year-olds in the audience. And some jurisdictions have banned, for example, facial recognition technology and things like that. The one last sort of thing I'll say before shutting up is that obviously all assertions of humans are really not just products of their own thinking, but of distributed cognition and the human and the machine that they use and everything that they've learned thus far, the conversations that they've had in a place like this, all of that goes into an assertion even of a person, and that's true in criminal trials too. And so I understand that what we really need is not just reliable algorithms, but reliable systems and effective ways of ensuring that when a judge or a witness or a juror is using AI for guidance, that they don't slide into things like automation complacency. Dr. Foraker's talk on Wednesday actually talked a lot about integrating AI into healthcare, and we need to integrate AI into criminal law as well. So maybe instead of trial by only human or trial by only machine, we could have something like trial by cyborg, where the human and the machine kind of bring out the best in each other. So let me stop there. I'm really excited about your questions, and thank you again for letting me talk to you tonight.
I forgot to do the PSB traditional giving of the lay, so if you would allow me. Great. And now we have about 15 minutes for questions officially, and then hopefully Andrea will be able to answer questions on the side of the stage. But thank you so much. And I will let you choose the questions.
Wonderful.
So we already have some evidence of machine learning being used in lacking representativeness of diverse populations. And so you didn't mention this in your talk, but I wanted to hear what you thought about the importance of inclusion of diverse populations in, training and validation.
Thank you for that question. So a couple of things come to mind. The first is that this issue has been litigated mostly in the context of the use of facial recognition for investigation purposes. An African-American man was falsely accused in Detroit of being the perpetrator of a robbery, and it turned out it was very obviously not him even on the video footage, but they just used this software to get to his house. And with respect to some risk assessment tools for determining whether somebody should be locked up pre-trial, for example, this has been litigated. In terms of proof at trial, we don't have a lot of examples of this being used to prove guilt or innocence. Usually that sort of thing is being used to identify a suspect, and then once they get the person, either it's obvious it's not them, or they have a lot of other evidence that they gather on the person, and they don't use that investigative tool that got them to this person as evidence of guilt at trial. But you're absolutely right that it's a major issue, not just for fairness, but also for accuracy. And so I think that's an example of why data set access would be critical. Now, there have been privacy concerns. Like, for example, we tried to get access to the FBI's DNA offender database, an anonymized version of it. And the FBI still refuses to this day, saying that they're too worried about the privacy of the offenders in the database, even with anonymized data. And I have to be somewhat skeptical of their claim that that's their main concern. But there's just so much inertia. It's very difficult to get over the privacy concerns. There's an algorithm for dealing with whether to label somebody like a risk of offending in a particular criminal activity dealing with a particular set of offenses. I'll just say that. That was trained on like a small group of people in Canada that were not, racially or otherwise diverse. And the problem was, well, the confrontation clause doesn't apply to sentencing or to anything that happens after conviction. So they say, well, there's no constitutional right to it, and there's no right to it under, statutes. So that's why I'm a little bit focused on the Constitution. Lots of people say, gosh, why don't you just call your congressman and, figure out a law to pass or something? And we all know how that works. So I think courts, if they understood why that was a major issue, might be open to thinking about this as something where all of those other concerns have to give. Thank you.
Yes, thank you for the talk. I have a quick comment on a question. I hear that this AI is also being used now on paroles, deciding paroles, and I just recently hear about this case where the inmate was not able to challenge the score because of proprietary nature. But my question goes, why this is different to, say, DNA evidence, where we need to trust that there's some accuracy in the test, and I believe sometimes have been challenged the results of certain labs because their practices were not correct. There were some, not care in the processing. Why this is different than any other technology that is being used in forensic evidence?
Thanks for the question. I don't think courts are saying it's different. I think they're just saying defendants don't have any right to look at a proprietary black box algorithm. And when it's being used in parole, the confrontation clause doesn't apply. And there's a case from Wisconsin, State versus Loomis, that kind of got some media play where they said, sorry, a person in a parole hearing has very few rights, and you don't get to see the black box as long as some judge puts their they don't even have a right to a judge putting their stamp of approval on it for general reliability. And so DNA evidence isn't any different. It's just that it's got this whole history of use in a clinical setting outside of the forensic science. Many forensic disciplines were created in the world of law enforcement. DNA is the gold standard, so to speak, in part because it comes from scientists. It was developed by scientists. So, but DNA isn't different. I mean, proprietary algorithms that purport to deconvolute DNA mixtures, there's also no right of access to those things. There's just little stamp of general reliability, and they just come in.
And I just want to make a comment about the trade secret, right? I agree there needs to be a protection, and I think your suggestion of an institution like FDA would be great, but you don't need to know how it works. What you need to is to benchmark it against something else. I think that gets away with this idea that needs to be disclosed, but I would hope that people will agree that to judge the reliability of any method, a gold standard test will be a way to decide if it works or not, right?
So I guess the question that has come up in the criminal setting has been, and maybe this goes to benchmarks, but if not, let me know. It's, a well-designed validation study can give you a false positive rate. You still want it to be done by somebody that's financially independent and all of those things, but yes. But a lot of these algorithms spit out likelihood ratios or risk scores, and it's hard to say against some ground truth, yeah, that likelihood ratio in that case is something that we should really trust. You could say that a program has a low false positive rate without really being able to say how much that number is reliable. And so the folks who've been arguing for more glass box AI have been saying that simply knowing a false positive rate against the ground truth is not enough, because we don't know the ground truth. We don't know what the right score is, the right likelihood ratio. And for that, they claim, maybe we don't need to see the source code, but we need a lot more testing and ability to put different inputs in and maybe get another expert system to start working against it.
So I just want to comment on the reliability aspect of what you're talking about. What we really need are repeatability studies that are done on these things. I can't tell you the number of models that get published with no proof or evidence other than a publication. And I worked in a clinical setting for 16 years where everything I developed goes into an applied clinical setting. We would always run retrospective studies before we cut things loose with a small number of clinicians that knew exactly what we were doing, and we'd be in common communication. The other possibility here is crowdsourcing. The reason why people like have embraced ChatGPT is because they say there's so many people saying, hey, I've got some pretty reasonable evidence that this is working and is providing what I think within certain limits. So we have this crowdsourcing. Another point, we had the FDA come to us on many occasions wanting to actually regulate clinical decision support systems. And we convinced them that it's a waste of your time. First of all, you don't have the resources to do any type of an adequate job doing it. These models are so complex that the experts are the people that are developing them. So what you have to do is actually pass regulations that suggest the type of evidence and the repeatability studies that have to happen to prove that these things are really operating like they're advertised.
Thank you for that. One thing that would be great towards that goal, I mean, I still think of, getting the license. The fact that, you need a license to be able to do any type of audit. And if you've got a proprietary algorithm that isn't giving licenses to academic researchers, I'm not sure where you start. And so one way to start, carrot, stick wise, whatever, is to use a rule of evidence that says you're not allowed to bring this in to a courtroom unless you do the following 5 things. But those are very helpful suggestions for what those things might be. Okay, thank you.
Hi, I'm Jacqueline Picos from Vanderbilt, recently graduated student. There's a black box when it comes to like algorithms and things, and to turn the black box into a glass box, if you will. I just want to know your opinion of if the defense were to be able to call their witness of their own to challenge the algorithm that is provided. And just I think on a personal opinion, if a program is not publicly available for scrutiny, I don't know if it should be used in a courtroom. Again, personal opinion. Yeah. But I see things where the black box can become a glass box. And we're also just not doing that.
Well, first, congratulations on graduating. Yeah, I think I think there's not very much play in that direction yet.
Because no one wants to give up trade secrets.
Yeah, I mean, one argument that the proprietors make is that open source algorithms for these purposes, they're not as good. Trulio, StarMix, it's just so much better than the open source ones that have been developed by nonprofits and whatnot. And it's hard to say.
Yeah, my response to that is, if it's so good, why don't you let someone else test it? Because if it was so good, it would be reproducible.
Yeah, and I have to think that it's about concerns about sneaky academics doing something bad with it, or also mistrust of lawyers too. That defense experts, some defense experts, the concern might be, will be future competitors, and that's why it feels like if you have a buffer of some kind, you can get that argument out of the way. But you see, that's the type of pushback that we're getting. Is we don't want this to be abused, but it's great to have the scientific community saying reproducibility is really important, and this is what this means in our world. I think if enough judges hear that, they will believe it.
Thank you.
Hi, brilliantly poignant talk, by the way. So you talked a lot about criminal justice. I think because we're in a medical context, malpractice maybe bears some discussion. I'd love to hear your thoughts on that.
Oh,
Thank you.
yeah. So I've been thinking about malpractice all week. If anybody commits a crime tonight, by the way, my malpractice insurance is fine. I'm still a criminal lawyer. But all of these tools that assist with diagnoses, for example, or flag people for risk assessment, 30-day mortality, all of this, I would think that they create a new standard of care. And it's like, well, why didn't you run this algorithm before you decided that that person was in this category, not this category. Or, you know, when you made this diagnosis, again, with the LLMs that are determining diagnoses from clinical notes, it's like, well, it's your own notes. And I came up with a different diagnosis that came out of your notes. You know, you all are the experts in this, not me. But I could definitely see these LLMs or just all the other types of algorithms that you're working with totally changing the standard of care. Same with just, you know, being subject to cross-examination on the witness stand if you're an expert for, you know, why did you do X, Y, and Z? What types of evidence is evidence that an expert reasonably relies upon? Those of you who have ever testified, that's something that you've probably had to have dealt with. This changes what is or isn't reasonably relied upon. So it's going to change all of those things as well, including in civil cases, absolutely. And cause of death, tort cases, not just malpractice, but yeah, products liability.
All right, Andrea, I think I get the last word. So I'm going to ask you a very open-ended sort of question to let you riff on. One of the fun LC talks we've had, although I don't think it was on the beach, was from the Innocence Project folks, who talked about all of the people who had been convicted of capital crimes who were demonstrated to be innocent on the basis of DNA data. And so I'm kind of, part one of this question is, do you think there are AI or other kinds of technical things in your purview here that would shift the balance of power away from the state? So what you were talking about was mostly state power rather than a balance of power. And I was curious about that. And related question, although maybe undermining that first one, is I don't think it's necessarily clear that anyone understands in detail how some of these more complicated systems work. So if I put Sam Altman up on the stand and I ask him about, you know, selection of some hyperparameter that, you know, was caused this output rather than that output, chances are pretty good he has no idea. And furthermore, I bought a third-party system that was a compiler that was part of my tech stack, and I just bought that. I believe it works, but I don't really know it works. And so it might be the case that a really accurate rendition of something important forensically is really mysterious to everyone. There is no one person who understands how it works. And so how does that play into our decision-making?
Thank you for that, Larry. That's a lot to riff on. In terms of exoneration, I should say that both TreeAllele and StarMix have been used in exoneration cases where somebody, based on like a manual mixture interpretation, which is a bit of a mess not right now, the person was deemed guilty, and they fed it through TreeAllele, and TreeAllele says, no, actually, clearly not the guy, and the person's actually been publicly exonerated. And so definitely, you know, these technologies and others can definitely empower criminal defendants. Maybe there's some false negatives there, you know? I mean, the way that I've tried to pitch this to law enforcement is you should care about the reliability of this stuff, because maybe a guilty person is being falsely labeled as not a contributor. And, you know, that hasn't worked so far, but I'm going to keep trying. I do think that because most criminal defendants are indigent, that the amount of money that they can pump into developing a bar of experts, a cadre of experts who even understand any of this, is low. And the academic community, or the scientific community at universities, I think it's our fault that more scientists don't know what's going on in a typical courtroom in terms of, wait, you're doing what? And so I think it's in part because there's no money in it. Not that that's not why academics wouldn't care about it, but just that it's not obvious that there's a whole big expert budget. And so partly I think that even though we have this adversarial system that relies on individual public defenders to do this stuff, we kind of need to have more of an adversarial design model where we have stakeholders at the design level and at the level of trying to figure out what types of testing need to be done. But, you know, Barry Scheck from the Innocence Project and I are on the same, part of the same subcommittee, and he's been talking about glass box AI for the past month, and so I think that we definitely have. I was joking with somebody the other day. The Innocence Project and the Guilty Project have a lot in common to care about fairness and accuracy. We just have to show each other that we'd be great bedfellows.
Wait a second. You just said something very important, which is most defendants are indigent, so they can't challenge the evidence. So that gets back to the first question, which is, the racism of the legal system and who is getting, convicted based on these algorithms and who is actually being able to challenge them.
I don't know what else to say other than amen.
Well, yes, thank you very much, Andrea. Please join me in thanking her for a great keynote today. And this ends the formal portion of our program. Please enjoy the rest of the evening. And I think we're done.